Okay, sound right. So I would even prefer a merger between the MPP and CPP as occurred in 1996. So respectfully, indeed, the implication is that if in the first Parliament of Ghana, the MPP had elected to contest parliamentary elections, which we all know from history that they did not, and in the course of the life of that Parliament, as actually occurred, a merger between CPP and MPP occurred, the status of a member of Parliament standing the ticket of MPP as an MPP MP shall not be touched, shall not be affected by the Constitution. So if indeed MPP and CPP had come by an arrangement, as they did actually in 1996, that for the Elembele constituency, the MPP will not contest, and the CPP rather will contest, which indeed was the case. But the MPP at that time already had a sitting member of Parliament in the Elembele constituency, and by virtue of that had more or less ceded his interest or right to a CPP member. Respectfully, that would not necessarily result in a vacation of the seat of the member of Parliament. So if indeed on account of clause 2 of Article 97, it has been decided that for constituencies already held by the MPP, for the purpose of the upcoming election, those candidates or those members of Parliament shall contest on a ticket of CPP or a different political party. Article 97 clause 2 suggests clearly that the status of such members of Parliament as MPs shall not be altered. So especially this, in my respectful view, fortifies the proposition we make that any decision by a member of Parliament to change his political identity for an upcoming election shall not necessarily result in a vacation of that member of Parliament seat. I don't know if I'm making myself job. I'm moving. So, right. So, apart from that, I'll refer the court to Article 47, Clause 5 of the Constitution, which is also a further indication. 47, Clauses 5 and 6 of the Constitution, which talks about alteration of the borders or boundaries of constituencies. So the point is that the Constitution, as I indicated, anticipates that the change in the composition of Parliament or the change in an anticipated composition of Parliament in the future shall have no effect presently. And that is supported by Article 47 Clause 5, which vests the Electoral Commission with the power to review the divisions of Ghana into constituencies at intervals of not less than 7 years. Especially as we stand before the court. Indeed, the number of constituencies for the upcoming 2024 elections has been altered by the Electoral Commission. Rather than 275 constituencies, we will have 276 constituencies in the December 2024 elections because of the alteration of the boundaries of the Boem constituency, with the result that there has been the creation of a new constituency for what we call the South people, the Santo Kofi, Lolobi, and Akpafu area. Clearly, the alteration of the boundaries of the existing Boem constituency now has not affected the status of a member of Parliament sitting as MP in the Boem constituency. That alteration only has effect in the December 2024 elections. So the point I'm making with respect to that, it is so clear from the Constitution that whenever a member of Parliament decides to change his political identity, or indeed the Constitution itself seeks to enforce a change in the composition of Parliament for the next election, it has no effect in the current term. If that were the case, presently, the SAR people would vote now and elect their MP, but they cannot vote now and elect their MP. They must wait until December 2024. I'll quickly wrap up with a swift address of issue 3, which is whether or not the declaration by the Speaker of Parliament of 4 vacancies.
I have a question.
Right.
And my question is, what is the point of the provision in Article 97(1)(gh)? Why did the framers of the Constitution put them there?
Right. Right.
I know you have addressed it in your,
yes.
if you don't mind. I know you have addressed it in your submissions, but I think that by reason of the last point made regarding Article 47(5), we need to have some light shed on
it. So the purport of Article 97(1)(g) is to prevent situations where a person in the life of a current parliament seeks to alter his political identity. That is frowned upon by the Constitution. So that if a person comes to parliament or having been elected as a member of parliament for a specific term as an MPP candidate or whatever political party candidate, in the course of the term of that parliament wishes to move to a different political party, the Constitution says that's prohibited. If the person also seeks to continue, and that is indicated by the use of the word seeks to remain in parliament, if the person seeks to continue his tenure as an MP during that term of parliament as an independent candidate, that's prohibited by the Constitution. Indeed, such situations have occurred in this country. It is not without history or antecedent. So clearly, the Constitution anticipated a change of one's political identity within the term of the current parliament, and not an anticipation.
Mr. Dami, can you give us one or two instances where
such occurred?
Exactly. Historical antecedents.
Right. Especially in the first parliament of Ghana, there were about 3 or 4 instances whereby my Lord, in the first parliament, there were 3 or 4, no, the first parliament, 1960, under the 1960 constitution, there were 4 instances in which some members of parliament crossed carpet or changed their political identity. There were the cases of J.A. Brima, Mumuni Baumia, Tampuri, and the Torona. They crossed carpet from the then governing CPP to join a different political party. Others also crossed carpet from the opposition party to the governing CPP. In view of that, the court would note that the 1960 Constitution had no such provisions at all. In view of that, for the very first time in 1969, a provision to that effect was enacted. And I refer the court to Article 75, Clause 2, Paragraph G of the 1969 Constitution. That's when it was introduced. It says every member of the National Assembly shall vacate his seat in the Assembly upon the dissolution of the National Assembly. A member of the National Assembly shall vacate his seat in the Assembly if J. he leaves the party of which he was a member at the time of his election to the National Assembly to join another party. This was the first time, the Second Republic, that a provision like that was introduced. The provision again was repeated in 1979 Constitution, and it was at Article 79. Article 79, Paragraph I of the 1979 Constitution. I. It says, a member of Parliament shall vacate his seat in Parliament in I, if he leaves the party of which he was a member at the time of his election to join Parliament, to join another party. At the time of his election, to join another party. So that's. Then the provision was repeated in 1982. Especially when the 1992 constitution took effect, a situation like that occurred. And I refer the court to the circumstance of Alhaji Wayo Seni, Professor Wayo Seni, who crossed carpet from the party on the ticket of which he had been elected as member of parliament to join another political party. At that time, the Speaker of Parliament indeed rightly ruled that he had vacated his seat. Especially this situation that we find ourselves in before the court had again occurred in Parliament, in the 7th Parliament. The Speaker of Parliament, just like the current Speaker, ruled that he had no vacation of seat. My respectful submission on that point is that such ruling was erroneous. The ruling that affected the status of Honorable Isiama, my lady, I love because the gentleman suffered a lot. The last Parliament he was declared to have been to have vacated his seat. This Parliament again too, his seat has been vacated. One person. He suffered a lot. So, my lady, and my point is that no matter the number of times an unconstitutional act is repeated, it does not ripen into constitutionality. This court has said in numerous cases.
So you're wrong in that?
Yes, this court has said in numerous cases. It started from Fuel and Tejera up to the recent matter, an ex parte charge or so. Yes, ex parte charge. 2007-2008, Supreme Court of Ghana report, volume 1, at page 213. That an unconstitutional act, no matter the times repeated, especially, does not ripen into constitutionality. So the fact that the previous speaker had ruled that Mr. Isiama Mwaku had vacated his seat, and that is being sought to be used as a precedent today, does not mean that it's constitutional. Especially, I'll be done on this case.
You had only 3 issues.
Yes.
And you have addressed them.
Well, I say that the court has the power to issue orders, and the orders and directions issued by the court shall be binding on anybody at all. Ex parte charge held same. Republic vs. High Court, Fast Track Division, Accra, ex parte Commission on Human Rights and Fitting Justice, which is an interested party. The court held at page 296 per Georgina Wood, CJ, that in relation to this matter, I think this was Dateba's ruling, Dateba JSC. Dateba JSC stated that in relation to this matter, we need to remind ourselves that there is no parliamentary supremacy under our constitution. Rather, it is the constitution that is supreme. As the interpreter of that constitution, this court's view of the meaning of a constitutional provision cannot be preempted by that of any other agency of the state. In short, the provision in the constitution means what the Supreme Court says it means, and not what even Parliament has declared it means. I end on this note. The Supreme Court's power to interpret the constitution has been long upheld from Benjamin Awuno Williams 1970, over 54 years ago, up to date. The constitution means what the Supreme Court says it means. End of matter. Thank you very much.
Zagati, it has been expressed that around the table that you are not allowed to speak, and yet the Attorney General has spoken extensively. I'm sure there's nothing you want to add. I'm very sure there's nothing you want to add.
My Lord, unfortunately, I agree with the sentiment that was expressed around the table, but I will not bore the court with adding anything.
We are grateful.
But I agree with the sentiment that was expressed. I think the Attorney General extensively referred to matters that was a statement of case without it being stopped. But you know,
because why are you pointing there? The sentiment actually came from this side, there, so you seem to be thinking it came from there.
My Lord, Justice Tampo, we know each other well, so I don't want to point someone.
But I was the one who stopped you, and I had made that sentiment that I think that if the Attorney General has had so much time to speak, I think that if you want to add something further, you should be allowed.
I'll just add one thing. I think I'll just simply add one thing. What I'll add is that, my Lord, the provisions of the Constitution with regards to the underlying principles that is established with regards to democracy, the establishment of democracy. If we interpret Article 97(1) G and H, my Lord, just now go. No. I haven't talked about the law. No, it is not. My Lord, there's no art of finding a man's construction and a man's face.
Please finish your submission.
My Lord, should it be interpreted in a futuristic manner, it will totally undermine the rights of an individual to freedom of association. And Article 21 of the Constitution. It will mean that once you come into Parliament under one party or as an independent, you must remain there forever. That is simply, my Lord, what I want to add. And I thank you for the opportunity.
Mr. Dantis, so your memorandum of issues, the 8, you still think they are all germane to the matters we are hearing? The 8 issues that you've raised, you haven't said anything about it. Nobody has said anything about the memorandum of issues. So I just want to know whether all the 8 issues that you've raised.
My Lord, just as the release, we focused on the release relating to Article 97(1) J and H. The memorandum of issues 2, we will end at issue 4.
But
5
says you've mentioned Article 97(1) J and H. So if you end 4, what are you telling us?
We consolidate 1 to 4 deals with the vacation of office.
Okay.
The memorandum 5 deals with whether the Speaker has the power to give the ruling he gave or not. And my submission that he doesn't. And we've addressed this sufficiently in our statement of case.
Okay. Thank you.
Thank you.
Yes. I think I consider this issue to be very germane.
Okay. Thank you. Sit down.
Mr. Gatti, I think I missed something. Did you say you are relying on your first to fourth issues and abandoning the rest?
My Lord, I'm saying that first 1, 2, 3, 4 be taken as one determines all the issues before the court.
So we should not expatiate on 5, 6, 7, and 8.
Well, not.
Pardon me?
But issue 5 is also relevant. Issue 5 is also relevant. Then we've addressed it extensively.
Issue 5 is also relevant.
Yes. And then issue 8. 6 and 7 can be abandoned.
by court, the judgment of this court will be delivered tomorrow, 12th November 2024. Yeah.
Lords are most grateful.
Lords, we are grateful. I mean, of course, being entirely the prerogative of the first defendant to file anything at all. Respectfully, I think that if the first defendant came before the court at the last agenda date, represented by counsel made representations before the court to file submissions at a certain point in time, elects not to do so, and then for no reason at all, elects also to appear before the court. Clearly, that is disrespect to the court. I made this observation because I'm the Attorney General, leader of the bar, and all that. Such conduct, with all respect, should not be tolerated by the court.
Leave it to us, Mr. Attorney General. Leave it to us. I would rather advise that as a member of the bar for which you are the leader, you should reach out to him at the close of these proceedings to find out if everything is all right.
Indeed, my friend, the chief state attorney, reached out to him on Friday to find out if processes had been filed by him. So now, I bet, hardly did we expect that he would not even show courtesy to the court by not showing up. Thank you very much.
Honorable Attorney General, I think at the last agenda, if my memory serves me right, you also said, when we asked that you should file processes, he said he had instructions to deal with the matters that he did, and then
he will go for further instructions.
So, if he has not been employed again,
no, my recollection is that was before the firm agreement and then statement as to when the process will be filed by the court. That was before it came. But that's fine. That's fine.
We have a lot
to deal with. That's fine. I'm very grateful. Right.
So if we retire early,
right,
because of the public interest in the matter, we should be able to serve the people in whose sovereignty resides.
Precise. I agree. I'm grateful.
Before you rise, my client, as we were arguing, the plaintiff came in, so we're grateful if it's possible.
We have signed the record.
Panel will be reconstituted. All rise.
All right, so the Supreme Court has scheduled tomorrow, November 12, 2024, to deliver judgment on this landmark case, which happens to be more of an interpretation of the Constitution regarding the declaration of vacant seats in Parliament by the Speaker, Alban Kingsford Sumana Bagbin. You recall that the Speaker declared 4 seats, that's Memphis Central, Aguna West, Suhum, and Fomena, vacant following the decision of 3 sitting MPs to contest the 2024 general elections as independent candidates, and of course the Fomena MP Andrew Siama, who elected to contest on the ticket of the NPP, having served in the 8th Parliament as an independent. This is the genesis of this particular issue and this case, for which the Supreme Court has scheduled tomorrow, November 12, 2024, to give a ruling. My colleague Jude Mensah Duncan serves through proceedings in court. Is joining us via telephone now to give us more. Thank you, Jude, for joining us. Run us through exactly what transpired in court today.
All right, so Nana, if you can hear me clearly, today at the court, like you rightly said, the Supreme Court announced that the case, the final judgment on the case will be delivered tomorrow at 9 a.m. And before that, the Attorney General made some adjustments to the statement of claim before the apex court. According to him, argued that Article 93 clause 1 and Article 47 of the Constitution make it clear that the Constitution of Parliament can only be constituted as an election, and that no order really from the Speaker of Parliament or any other person can change the Constitution or the Constitution of Parliament. We thought to make that argument in court. The earlier lead counsel for the plaintiff, that Alexander Martin,
right.
Honorable Dozati also made some comments at the court today, where he also sought to back out some parts of the statement of claim and arguing that he really didn't add up the argument he was making or the relief that they were seeking in court. So the story or the big news today is that the Supreme Court has settled 12th November, that's tomorrow, for the final judgment on the issue of the bond.
Hello, Jude.
Also the court, and I think that's mentioning that counsel for the Speaker of Parliament started your story giving show up in court today. Honorable Alexander Martin for reading the media and just make it up.
Well, Jude, kindly join that. Let's hear what Mr. Alexander Penyomakin has to say, or his counsel, and then we can continue with the conversation.
So, basically, I would go outside of the law and talk a bit of politics and nation building. I humbly hold a view that as a political class, we owe a duty to ensure the peace of the country and to strengthen the pillars of democracy. We can only do so if we respect the law and act in a manner that the citizenry would have confidence in us. We have 3 weeks to go for an election, more or less. I think that the peace of Parliament is entirely in the hands of Mr. Speaker. If you follow the chronology of events, Mr. Speaker could have done better, considering the fact that even before initiating this action, I had gone to him to discuss the fact that Honorable Harun Idrisu had raised the matter on a political platform, and the fact that we should come together and deal with the matter. He assured me that he would guide the process. Unfortunately, that did not happen. I eventually had to file the writ upon seeing the petition of Mr. Idrisu to be argued on the House floor. He again went to Mr. Speaker. That Mr. Speaker, now that you have knowledge of this petition by Honorable Harry Nedrusu, does that mean that you are going to take a step? He said no. The application by Harry Nedrusu would have to be admitted by him first, and that he has not admitted any motion. So I should be rest assured. Then the next stage of serving the writ on the legal directorate. There again, he gave me assurance that because of a certain circular, the directorate could not receive the process until the next Monday. Then I became alarmed when we got onto the House floor. And this time around, the petition from Harry Nedrusu was not a matter in issue, but rather Honorable Atuforsen was going to invoke Order 93 to make a statement. We said, okay, fair enough, let's see what will happen. I tried to engage my colleagues on the other side, but you see, they were hell-bent on the politics they wanted to do that day. And from all the actions, it was clear that Mr. Speaker was in the know of whatever they were going to do. So he just called Atuforsen, Dr. Atuforsen, and he came out with this thing. We argued it, and unfortunately, Mr. Speaker announced that he was going to give a ruling on Thursday, when he had assured me that he wasn't going to give a ruling, but because of the court process and all that, he was going to wait so that we all abide by the reasoning of the court. Because according to him, the matter was a constitutional matter. So for me, it was a big surprise that Mr. Speaker would go out of his way to make a ruling, which immediately made the NDC proclaim themselves to be majority, although he himself continued to address me as a majority leader. Fast forward, we came to court, the court intervened, and now the new argument of Mr. Speaker was that he didn't give a ruling. He only gave an opinion. He expressed a view on the matter. He met us on Tuesday, the 22nd of October, at a pre-sitting meeting. And at the pre-sitting meeting, I told Mr. Speaker that, well, you are saying you have received the court process and that you have not declared the NDC the majority. Now that they are sitting on our seat, what are you going to do, Mr. Speaker? Mr. Speaker told me that that is the responsibility of the clerk. He later repeated the same thing to the Council of State and the Peace Council. The clerk to Parliament made sure that he had arranged our seat, the majority caucus, our seat, at where we are supposed to sit, the right of Mr. Speaker. Place our name tags there. The NDC came to remove them. Mr. Speaker was aware of this. He watched and continued with the proceedings, where I think Mr. Speaker failed the nation and failed our democracy. And I do so with utmost respect. Some of the NDC guys are trying to suggest that expressing my view on his conduct amount to disrespect. Let me say it clear that I will be the last person, I repeat, I, Kwamena Afenyo-Markin, will be the last person to disrespect Mr. Speaker. But Mr. Speaker should not think that he's a king. He's an emperor. He's not an emperor. He's a democrat. Therefore, he shouldn't be too sensitive to divergent views and opposing views. What he's doing, in all humility, is wrong. So my friends in the NDC should open their eyes and ask themselves, if they were the ones at the receiving end, how would they react? The NDC would have raised hell on this matter. But we have been calm in all of this. All right? Now, again, another opportunity presented itself on the 7th of November when Mr. Speaker enforced our recall petition. And again, he knew that the only contention was for the NDC minority to move to their seats. Dr. Atuforsen said, well, for them, it was Mr. Speaker's announcement that made them behave the way they were behaving. So until Mr. Speaker makes an announcment, they will move. Dr. Forsen said it at the pre-sitting meeting and then raised it again in another forum. On a news file,